So the first of the exceptions under 804 is for former testimony. Now, we've seen former testimony before, and just in a different package. Under 801 D1A, if a person's prior statement is inconsistent with their current statement, then it can come in as substantive evidence if previously it was offered in a deposition, a hearing, a trial, or other proceeding that was under oath and subject to the penalty of perjury. This one is different because this prior testimony exception has a greater requirement. It is not enough to come in under this exception that the prior statement merely be under oath, subject to the penalty of perjury. To come in under 804 B1, the prior testimony has to be at a deposition, a hearing, etc. But it also has to be subject to cross-examination by the person that it's being offered against currently, or that person's predecessor in interest. And what that essentially means is that, let's say that you sue Amazon, and Amazon cross-examines you. Well, then Amazon sells its interest, say, to Apple, and then Apple then is the party in the lawsuit. Well, if Amazon has been entirely subsumed within Apple, and Amazon cross-examines you at the first hearing, then the Apple now has the same interest that Amazon previously had. These issues can get complicated, but they tend not to get complicated at the level of the bar, or the bar examiners tend not to go into that complexity. Just know that either the same person has to cross-examine you, or the same person has to have cross-examined the witness who it's now being offered against, or a person who previously had or concurrently had the same interest as the person the testimony is now being offered against had to have previously or had the opportunity to cross-examine the witness who now testifies. So in Commonwealth versus Bazemore, we're looking at preliminary hearing testimony. So there's nothing quirky about a person with a previous interest in the same issue. This is the Commonwealth that had a witness testify at a preliminary hearing. And at the preliminary hearing, the witness said things that were obviously adverse to Bazemore, and that witness is now unavailable because that witness has now invoked his Fifth Amendment right against self-incrimination. And so he's unavailable under 804 A1 because he has a privilege against testifying. So the Commonwealth then wants to bring in his previous testimony under 804 B1, the prior testimony. Okay, the question then is, did Bazemore have the opportunity to cross-examine this witness at the prior hearing, at the preliminary hearing? So those of you who are aficionados of criminal law will know that at most preliminary hearings, you rarely expect ever for the prosecution to lose. That it's rarely the case that a case will be dismissed at the preliminary hearing. And so as a practical matter, the preliminary hearing is your opportunity to learn what the prosecution has on your client, to the extent the judge will let you discover the case. And it's usually pretty limited at the preliminary hearing. And it's also the case that the defense may not want to preview its defense, may not want to ready this witness for what's coming at the trial. So there's every incentive for you to hold back in cross-examining the witness at the preliminary hearing. So did you truly have the opportunity and interest in developing the preliminary hearing testimony through cross-examination if you represent the criminal defendant at the preliminary hearing? As every criminal defense lawyer will tell you, 99% of the time, no, you really weren't hitting the witness with everything that that you had, because you are holding this back for trial, because you're not going to win this at the preliminary hearing. The problem, though, is what happens then when the case then moves to the trial. If the witness becomes unavailable, you now have this witness who was examined at the preliminary hearing. You had the opportunity to cross, and the things that impeach the witness's testimony are not now part of the record. You're not then the jury will not then hear things about prior inconsistent stories or the witness's prior convictions if that previous testimony is then offered under 804b1. So a lot of people have argued that the preliminary hearing, even though you have an opportunity to cross-examine the witness, it's not a meaningful one, because that's not strategically what any criminal defense lawyer would do. Courts have almost unilaterally held, or rather universally held, that that preliminary hearing testimony does come in as prior testimony. However, what about the circumstances of Bazemore? In Bazemore, the defense lawyer had not at that point been given certain information that he could have used to impeach this witness. The fact that this witness had offered prior inconsistent statements, the fact that this witness had a criminal record, and in fact that this witness was being considered as a suspect in the crime, and in fact was then later indicted in connection with this crime. All those things undermine the witness's testimony, and the defense lawyer didn't go into those things at the preliminary hearing, not because of strategy, but because the defense lawyer wouldn't have even had the ability to do it, because that information had not at that point been turned over by the prosecution to the defense. Well, the Commonwealth in this case argues that rules of discovery don't provide for that, and that the court shouldn't fashion new discovery rules to require that information be turned over at this point. The court in this case, however, says, okay, fine, we're not writing new discovery rules, but you're rolling the dice. If you, as the prosecutor, choose not to give the defense information until the trial that could be used to effectively cross-examine this witness, that you will then be required to turn over. If you wait until then, you can't say that the defense then had the opportunity to cross-examine this witness at the preliminary hearing without the information that you could have turned over earlier. You don't have to turn it over until trial, but in waiting until then, you have hampered the ability of the defense lawyer, if he or she chose, to go into this kind of cross-examination at the preliminary hearing. And so, two takeaways from this. One is, it actually does not make sense to regard the preliminary hearing as an opportunity to meaningfully cross-examine a witness, because that's not what defense lawyers tend to do strategically. For really good reasons, they tend not to do this at preliminary hearings. Nevertheless, it is close to Hornbook black letter law that prior testimony, even at that preliminary hearing, is admissible if the witness becomes unavailable under Rule 804b1. But if the prosecution does not provide the defense lawyer the opportunity, the ability to do that cross-examination, whether or not he or she would have done it, if the prosecution does not provide the discovery that would have allowed an effective cross-examination at the preliminary hearing, then that preliminary hearing testimony is not then admissible under 804b1. So key thing is, so long as the defense or anyone had an opportunity to cross-examine this witness on these facts that are going to be testified to previously, and that witness becomes unavailable under 804b1, that prior testimony is admissible against the lawyer who previously had the opportunity to cross-examine the witness on that issue.